Hi, I'm Gerard Virga, and welcome to Season 1, Episode 5 of the Florida Family Law Attorney Podcast. And today we have a very special guest, Don Moll. He's a CDLP, and you may know him as Don, but you may also know him as the divorce mortgage guy. He's a sponsor of so many family law section bar events, and he's always set up there to answer questions and to explain this process. So, Don, tell us a little bit about yourself and give the audience a little introduction on how you became the divorce mortgage guy.
So this is my narcissistic segment.
Yes.
So I've been in the financial services industry professionally for 25 years. I was raised in it. And for the last 25 years, I've been in the capacity of either investment banking or lending. And the last 5 years of my life have been dedicated to divorce mortgage planning, which is something that when people initially hear it, what is that? And I didn't know it was such a thing. So that's what I've been doing literally the last 5 years of my life, is going all across here in the state of Florida and, in essence, enlightening professionals like yourself on the fact that there really is a difference than what is traditional when you think of mortgage originating. And so that's been my life for the last 5 years.
Well, what I find is most of the time people who are doing something involving divorce or family law, it kind of comes from some underlying passion. What brought you down this path to take this on? Because it's a special kind of situation. It comes, I'm sure, with a lot of issues. Unfortunately, a lot of people leaving a divorce don't have stellar credit following the divorce, or there's been some financial hardships, or their incomes are going to be reduced, perhaps their disposable incomes, their debt to income ratio is going to possibly change. They're not going to have the two incomes anymore to qualify. So what made you want to take on all those challenges and help people in this situation?
Well, I think you nailed it. We all have our why. And so my why goes back to the fact that, unfortunately, I'm a divorce survivor myself. And when I went through my divorce at the time, I'd worked at one of the largest banks here in Florida, what was SunTrust, now it's Truist.
Right.
And so when it came to the marital home, and the questions that I had, there were very little answers for the questions that I had. And I had a lot of resources. And so fast forward about 5 years ago, when I'd heard about, this divorce mortgage planning. I said, and I just said, what did you just say? And this gentleman said, so-and-so in Tennessee was talking about divorce mortgage planning. And that led me to a woman by the name of Jody Bruns. And I love to tell the story. Gerald, I didn't know this until last year, but it wasn't until 1974 that women in this country could open up either a bank account or get a line of credit without a man cosign. It was 1974 when it changed. And I'm 55, so I was raised in the 70s. And I'll never forget going to the equivalent of like a Macy's with my mom one time, and there was some sort of a special, hey, you open up a credit card, you get a discount on your purchase. Dad was the money earner, mom was the caregiver for my sisters and me. So she applied for it, and the person behind the counter said, "Oh, that's your husband's money, not your money. You're not going to qualify."
Yeah.
Wrong woman to say that to.
Right.
So shortly thereafter, she did get herself a credit card. It was an Amoco, remember Amoco gas station? She got an Amoco gas card. I didn't realize the significance of it at the time. And it was actually about 4 years later, in July of 1978, when a group of women, actually the leader of that group is a woman named Carol Green. And Carol Green with 7 other women said, you know what? Shame on the banking industry. They're only serving half the population, which is men. So we're going to create our own solution. So they created the first women's bank, and they opened up their first women's bank. It was called the Women's Bank, downtown Denver. And when they opened up their doors, there was a line down the street, and over $1 million, which is the equivalent of $5 million today, was deposited. So I share that story because it really kind of correlates with our story. And that was a woman by the name of Jody Bruns going through her divorce in 2000, mortgage originator, accounting professional by background. And she realized, shame on the mortgage industry, because we're trained to help the couple when they purchase the marital home.
Right.
But it's this journey of a divorcing homeowner cannot be more opposite when they bought the marital home. So she said, you know what? I'm going to be the solution. So she created the Divorce Lending Association. And with that, a curriculum where loan officers all across the country, if they choose to do it, they can go through and earn that certified divorce lending professional designation. And she's literally not only changed the trajectory of my professional career, but my life, because for the first time in my career, I know I'm having a positive impact on divorcing homeowners, avoiding some of the many common pitfalls that they otherwise just unfortunately aren't going to learn from their traditional mortgage originator.
Yeah, that's true. And I will tell you this as a family law attorney, one of the things that really scares me the most is when they start asking me questions about refinancing. Can my VA loan be assumed was one I had last week. If someone assumes my VA loan, does that mean that all my VA benefits are still tied up? And I do not have the information. I don't have in law school, we don't spend a year on all the minute details of refinance and assumptions. All I know is up until recently, I've always heard that you could forget getting an assumption that the bank was going to want to refi. But now it seems like since the rates have gone up, I don't know if it's wishful thinking on the parts of clients or if it's, a reality, but I keep hearing, I'll go assume the mortgage. And I'm thinking, I haven't heard anybody successfully assume a mortgage, I think, since like the 70s. But, maybe it's out there, maybe it's making a comeback.
It is. And it's funny you bring that up because, I do a lot of this. You as an attorney, you need continuing legal education credits. So I lead with education. Last year, I gave over 16 CLE lectures. That's either on the state level, regional bar associations, or individual law firms. And about 2 years ago, I didn't realize, but there were 4 judges that happened to be attending one of my CLE lectures in a courthouse. And they came out and I ran into them shortly afterwards. And they said, "Hey, you're that divorce mortgage guy. We were in your lecture." And the one, I give her credit. She said, "I realized after attending your lecture that I had just signed off on orders that morning. And there was no way the wife was going to be able to effectuate that equity buyout. Can you come train us?" So that started it. So then in January of this year, we just received accreditation from the Florida Supreme Court to give continuing judicial education credits. So I gave my first continuing judicial education just last month. It was in the 9th and the 18th district, which is Central Florida. And to your point of, they didn't teach us this in law school. Let me tell you, the looks on the judges and the general magistrates who were in attendance of my lecture saying, "Wow, we realized we're just now thinking back of past cases where, we didn't know this." And I said, look, it's not your responsibility. Your responsibility is to navigate the law. It's just the reason why you bring in potentially a forensic CPA, or if you're going to be imputing income, maybe you bring in a vocational expert. You don't stay up late at night reading divorce mortgage underwriting guidelines. I mean, you're not expected to.
I think there's so much mystery too with what goes on in the underwriting. I was talking with another guest on the show who's a realtor. And so I'm going to ask you maybe the same question I kind of asked him. I've had lots of clients who say, "Will you write a letter and explain that I was in a divorce from this time to this time, and if things are kind of back on track, or the judgment's in, or he's taking responsibility for this pursuant to the judgment." And of course, I'll write a letter as long as it's truthful, and I feel like I'm stating the truth, and I normally will attach the judgment. Does that actually help in the underwriting process? If somebody, hey, there was a blemish on the credit, but he caught it up and there was a divorce going on and maybe the wife didn't pay or maybe the husband didn't pay. Is that just wishful thinking on the part of the client that helps, or is that a service?
In terms of underwriting, and in fact, going back to that when I was in the courthouse in Central Florida giving my CJE, I said, by the way, all of you here in this room have the opportunity to be David Copperfield in helping debt disappear in the eyes of a mortgage underwriter. Because when I'm involved, and I can be very strategic if there is, whether it's individual debt or joint debt, and how that debt is assigned can be very helpful in, say, one spouse, say it's the spouse looking to retain the marital home, retaining that and understanding that in the eyes of an underwriter, when one debt is assigned and then it's written into the MSA and then we have a final judgment, that now is a court-ordered assignment of debt. So in the eyes of the underwriter, that becomes what's called a contingent liability. So even though that particular debt obligation is still there, it's removed from, say, this spouse looking to refinance the home. It's removed from his or her debt to income ratio. So that can be very helpful in how we structure MSAs for whatever spouse, whether they're looking to retain the home or even purchase it.
Are there any magic words that need to go in that MSA? I know mine are normally husband will be responsible for the Visa card ending in 549 and will indemnify and hold wife harmless. Is there anything else I need to be putting in that MSA that helps the underwriter get that off?
Precision of language is key with underwriting. Give an example. We had a case where the wife was looking to retain the marital home and her debt to income ratio was really tight. And what was at stake was the fact that she had signed off on her son's student loan like a year or two prior. Well, the way the MSA read was that husband, will be responsible for all future student loans. And even though he agreed, say, hey, no, I'm going to be paying my son's language. The underwriter said, no, it says here all future student loans. This is an existing student loans. So it was denied. Okay. So I get it. It's a war of words. Precision of language is key. So when it comes to say, and you mentioned loan assumption. Well, there's two types of loan assumptions. And that's where oftentimes I'm brought in, because part of what I do is mortgage origination, but it's only a small part. Because when clients come to me, they're not, it kind of helps to understand mortgage origination from the first place. Typically, you, and I'm sure your audience here, everyone's been through the mortgage process. And that's typically, okay, well, we're excited. We want to buy a home, whether it's a first-time home or a new marital home, or we're upgrading, whatever the situation is, or we're right-sizing. So they talk to a traditional mortgage originator, and that originator is going to say, okay, listen, I need some financial documents from you, whether you're self-employed or you're an employee. I need some tax returns. I'm going to pull your credit report. Based on that, I'll tell you how much you qualified for. Guess what? It's not a very difficult process from a mortgage origination standpoint. But now, when clients are coming to me, last year I was brought in on 219 divorce cases. This year, I'm tracking over 300. They're not in mortgage origination because we're not pooling assets together. We're now dividing assets. So I was at I am employed by an independent mortgage bank, and we had our conference last November. And I'm not one of the top producers yet, but the top producers, they were having breakfast. They said, hey, Don, can you come up, sit down with us. What's all this divorce mortgage planning we're hearing? So I said, all right, if you want to have this conversation. So I said, we're dividing assets. So we're looking at the ED schedule and if there's a quadro and this and that. These are top 1% of loan originators in the country. These are all 7-figure individuals. And they said, what's a quadro? And they kind of snickered. They said, why are you talking about a man's sexual performance about a mortgage origination with an ED schedule? Okay. They were serious. So it's just lack of understanding that, hey, listen, they're not, I was referred to a case, retired judge who's now a mediator, right? And said, oh, here's 3 people you should talk to. I was one of them. Well, I talked to the individual and he said, it turned out there was no need for a new mortgage. They could have done one of the assumptions, one of the two. I said, no, before you go down the rabbit hole with someone like me, go, do this. And he said, well, the other person told me that I had to do a refinance with it. Right. So, well, I'm not disparaging that other individual, but it's, again, going back to Jody Bruns and the Divorce Lending Association saying, shame on the mortgage industry. We're just not trained.
There's a big opinion, at least in my discussions with clients, that they want you to refinance because they're going to make more money that way than an assumption. They feel that's why I have never heard anybody really around here, getting an assumption or, so I think, that's invaluable if there's some methods that you can get an assumption, because seeing origination fees are not cheap. And then you look at the current interest rate, why would you not want to try to assume it at for instance, like a 2.2 was the case I had the other day. And now I think they were looking at about a 6.8. So why would you not want to assume it if you can assume it? So having somebody to help navigate that process, honestly, you could be worth your weight in gold, by the time if you could successfully navigate it toward a assumption as opposed to a refinance. Well, let me ask you this about the CDLP and that designation you carry. What length of training do you have to go through? What's all involved in getting that?
Sure. So again, it's offered through the Divorce Lending Association, and it's been, I'd have to look what is involved now with the curriculum. But there's a couple of programs out there, and I'm very familiar with all of them. The difference, I would say, with the Divorce Lending Association, first of all, it's offered by a former mortgage originator. There's some programs offered out there that they're not practitioners. They've never even originated a loan, but yet they're proclaiming to be experts in divorce mortgage planning. You and I know the value of that. So, but here's the key. It's ongoing. I'm required to maintain continuing education credits within the Divorce Lending Association. And we have a standing coaching call on Monday and Friday. And so it's ongoing. And then, okay, call me a nerd, but Monday through Friday, I'm in the gym. It's a non-negotiable, but I'm listening to a 3-year library of coaching calls. And whether that's on quadros, whether it's on, defined benefit plan. And, that's a big part that when your clients are coming to you, then you're saying, hey, go talk to a traditional mortgage originator. Well, hold on. We also have to talk about the financial and tax planning component of it. Because as you know, oftentimes we're dividing assets. If it's a defined contribution plan, then it's a quadro. And if it is a quadro, if the client's younger than 59 and a half, your traditional mortgage originator is going to say you can't use that as a qualifying asset. I'm here to tell you that you can. Number two, if it's a defined benefit plan like a pension, okay, are you doing the immediate offset method or the deferred distribution method?
Right.
Both have implications. Both we want to know about in talking with Enter, the financial planner. So as we're all working as a team, that's really the benefit of, and that's where we're trained as CDLPs, that our value is coming in early as a member of the professional divorce team. And we're not going to be your traditional mortgage originator with that commission-based model,
Right.
which is a very profitable model. And I'm not disparaging it, right?
Oh yes, I've seen clients come in and we've divided the assets, we got them the opportunity to refi the house, and when I see them later and they're like, hey, that was a $10,000-$20,000 refi tacked onto the mortgage, and I'm really having second thoughts about if I want to do this or not, or do I want to try to sell it now, or what do I want to do, and then add in the rate that we have now, and it makes houses unaffordable at times.
Gerard, when they retain me, it's creating a fiduciary relationship, meaning it's solution based. And if one of those solutions happens to be a refi, okay, then you can take that to a lender of choice that you want, right, or you can use me.
Right.
But we have to identify so many other aspects, so many other potential pitfalls before we even get to, let me take a mortgage application. That's the big thing that people have to understand.
What I find fascinating about you and about this conversation, and when I came across you at the family law review course, I think in January when you were out there, for over 20 years now, I have just simply been like, well, go to your local bank. Who do you bank with? Who do you have the best relationship with? Is there somebody at a local bank who maybe knows you, who's, a little more personable than a big bank, and, tell them what's going on and ask them if you can refinance. But, I think it goes back to something I've been saying now for a while. Lawyers, a lot of times, and I'll pick on myself, for a large part of my career, I was the case. I was the person doing the questioning. I'm the one driving the boat. I'm steering this case where I think it needs to go within the parameters of the law. But I think the older I get and the more experience I have, it reminds me of, I think it was a quote by Steve Jobs. He said, I conduct the orchestra. That's what I do. Because I realized, like, Steve Jobs was not an engineer. He was not a, chip maker. But, I have the vision of where I'd like to get these people, and get them in their life and where they want to go. But putting together that team, that orchestra of professionals is really what, to me, the higher calling perhaps, because if I can get someone like you in there early and we can come up with a very solid game plan that will, almost guarantee that they're going to get, to keep the house, to refi it or assume it, or, hey, if we word it this way, the underwriter's going to, look at the application totally different than if it's worded this way. And those little nuances that come with having the right team, can mean the difference between a result that looks good on paper, but can't really be executed, or one that looks good on paper and we can execute it. So, I think sometimes for people out there who are going through this, who are not lawyers or not divorce professionals, I hear a lot of questions about, why do I need to pay an accountant? Why do I need to go hire the divorce mortgage guy? Because it's so much information that's in so many varying topics in a divorce case. Having those resources, having those tools, can make such a big difference. And then, perhaps we're going to trial over the house and, one side's thinking the other side won't be able to refi it and they just want it sold because they want to move on with their life. Having this information where you could quickly refi it, or perhaps maybe we get a proposed marital settlement agreement, run it through some kind of a pre-underwriting that, hey, if this gets signed, will they qualify? Maybe that makes the difference between a trial and a good settlement for everybody. So that's what I've learned. Like, the team is much more important. And I start to think of myself perhaps as maybe the quarterback of the team, or maybe the talent scout to scout talent and get the right people on the team, building that for the clients.
And I often, you mentioned it, and that's often, especially my CLEs, I say, look, what as an attorney, what as a legal option isn't necessarily a mortgage option. And while that, like you said, it may looks good on paper, but then post final judgment, there's no way. Oftentimes, I've got 4 cases right now, post judgment. All 4 had there been language that I would have advised to be included for mortgage underwriting purposes, all four would have been able to effectuate their all equity buyouts. 3 of the 4, the ex-spouses are saying, you want me to do what? I mean, as you know, it's not the end of the world. There's an amendment. 3 of the 4 ex-spouses saying, no, I'm done. And especially the contentious
or you might find that amendment's costly. It may be, yes, I will agree to an amendment, but while we're amending, I want to try to amend this as well. And it may be something that you had won in the negotiations or.
Sure.
Yeah. Sometimes the goodwill is pretty damaged. Unless it's got something for the other side in it. But you touched on something a minute ago, and I don't know if you feel comfortable asking it. It's not something we had discussed earlier, but you mentioned that the judge came to you and said, I wish I had known that, what advice did you give the judges? What was it that they were having concerns about, and what was it that you were able to shed some light on?
Well, I'll keep it G-rated. What a recent chief judge said, thinking of these past cases. Let me give you an example. One of the big ones is time.
Right.
For example, you've drafted up, I'm sure, plenty of MSAs where it says, okay, retaining spouse says 60, 90, 120, 180 days to refinance the marital. Sound about right?
Yeah, that sounds pretty normal. I try to shoot for 4 to 6 months because I did a refi, and I was very surprised about how long it took to do the refi. But I think that was also when it was 2.2 and everybody was refinancing and I was just in the pile. But, I try to steer away from 90 days and try to do 4 to 6 months, but maybe I haven't been given enough time. Let's hear what you have to say about this.
Sure. Well, let me give you an example. Let's say if the retaining spouse has been the primary caregiver. So let's say it's the wife and she's been maintaining the home. She wants to keep stability of the children in the home and the schools and the friends, et cetera. And she's the impecunious spouse. So she's going to be utilizing support income, which we use, alimony, child support. We utilize it for mortgage qualification purposes. But there are guidelines that we've got to stand by. We've tried to make it easy. Jody came up with a very catchy phrase. We call it the 636 rule. So when utilizing, let's say it's alimony and child support, we need 6 months of payments received as ordered prior to initiating a mortgage application. So we need 6 months. So if I see, she's got 180 days to refinance and make time out, we need 180 days just to get started.
Right. Okay.
And that's if those payments have been received as ordered. So let's just say the order states $1,000 is due on the 5th of the month, and you've got a payor that has fluctuating income or just isn't consistent. Maybe says, well, I'll pay you $500 on the 15th or $500 on the 5th and $500 on the 15th, or I can't pay you this month, but I'll double up next month. Well, in underwriting, it goes back to the consistency and stability of income, whatever kind of income that is. In this case, support income. Then the underwriter says, well, hold on, that's not consistent and stable income. It's not pursuant to the order. Can't use it. So that's 6 months on the front end. And then once we have 6 months of payments received as ordered, now this is for conventional financing, then we need to show per the MSA that those payments will continue for a minimum continuance of 36 months. So we need 6 months on the front end prior to starting the mortgage application. Then I need to show the underwriter, hey, these are going to continue for an additional 3 years. Well, if we've got a child that's 17 and sans any other special needs, those payments will cease at the age of majority of 18. Well, guess what? I don't have the 36 months continuance. So that's where I see these MSAs drafted up. I was like, well, I had one the other day. I was brought in a mediation. And as you know, July of 23, we had an amendment to the durational alimony reform. And what that stated was now short-term marriages are defined as greater than 3 years and less than 10 years. And the starting point is 50%. And most of the jurisdictions I've been around all over the state, most are 50% is what they're ruling. Well, if we have a marriage that's less than 7 years, if you do the math, we need 6 months on the front end, 36 on the back, we need 42 months. We're not going to have it. Right. So the way in this mediation, they drafted up, they're saying, well, Don, it's going to be 39 months of alimony. I'm like, well, that's not going to work for her to be able to utilize that for qualification purposes.
So what you're saying then, and something like that, if the other side would agree, maybe take a lesser amount of alimony for a longer duration, and then maybe start the refinance period after the pecuniary spouse has made 7 on-time payments. And if he doesn't make the 7 on-time payments, then we don't start the clock on the refi until there's been 7 on-time payments. So you have, at least the 6 months, and then having the back end, the tail be as long as you need it to be, maybe by perhaps lowering amount and expanding duration and seeing if you could sell that to the other side.
And that's exactly what we did. Fortunately, I've had a good relationship with the opposing counsel. So I said, hey, look, this is how it's got to work. And, understood. And that also brings up another point. In fact, what we did in this case as well, now I think about it, but temporary orders. Temporary orders will start that 6-month clock.
Okay.
So I said, hey, look, if if in this case he wants off this mortgage, I said, well, then get a quick order. And it doesn't matter what that award amount is. Because the question then is, well, what if we think that the final award amount is going to be different? Like, that's fine. Temporary award will start that 6-month clock. And then once we get that final award amount, we just need one receipt of that final award amount and we can initiate the mortgage application.
So if you have 6 months of temporary alimony, let's say $1,000 a month, let's say it's a miracle case, and at the 7th month you're in trial, and then it's no longer $1,000, it's $600 a month alimony, you can still use that. The bank used the $600 figure, I guess, as the income at that point?
It's going to be whatever the final award amount is.
All right. Gotcha.
Okay. Now, I said a key little word there. That's for conventional. Now, you mentioned about, and it happens where during divorces, credit scores get hit.
Right.
Again, you've got conventional, which you've heard the terms Fannie Mae, Freddie Mac. Well, the government insured loans, the FHA, the VA, they're going to require, since it's insured by the government, they're going to require only 3 months payments. And sometimes, if someone's credit isn't going to pass for conventional, then we'll go the FHA. And then that's a little quicker. But then, speaking of alimony, in light of the Tax Cuts and Jobs Act, there's no longer a tax incentive for the payer of monthly alimony. So if the assets are there, I'm sure you've seen this, but if the assets are there, we're seeing it. Okay, I just want to completely disentangle myself from you. Here's a lump sum and I'm done.
Yeah.
Okay? Well, that's great. So now if we're working with the spouse that's the recipient of that lump sum alimony, he or she has a healthy bank account, but he or she doesn't necessarily have income. We need to have income for the underwrite.
Right.
So how do we create that? And that's where we do have some very creative solutions and strategies on how to create qualifying income in those situations.
Let me ask this. Let's say that, sometimes there's income producing property in the divorce. Let's say it's a rental house. It has a history of being rented when it was, part of the marriage. And let's say wife gets the income producing rental house. Can she use the income it was making during the marriage to show the pattern, that it's been making this for 3 or 4 years prior to me getting it? Does it restart the clock when they get it, awarded to them in the divorce? How does that work?
So in terms of they have a rental property and she's awarded the rental property has a history of rental income. Can she use that rental income for qualification purposes to refinance? Let's say they're both on that mortgage. You're saying, so she's awarded it, but she needs to refinance it, get him off?
Yeah.
Yeah, that goes into it.
And can you use, though, the income it was making during the marriage? Will that carry over? Can you use that history to say it's been making this for 5-10 years? Or
sure.
Yeah,
for qualification, yes.
Okay. Let me ask this, what do you think the most common option divorced couples have when it comes to that, the marital home and not selling it, but trying to refi it or assume it? What do you think the most common options really are?
Well, look, during the pandemic, we were at historic lows. You said you had one recently, it's 2.2.
Yes.
I'd be 1,000 Vegas and I put my money down. When do you think that was done, Don? I'd say probably during the pandemic when we had historic lows. Well, unless people were living under a rock, they took advantage of those low rates.
Right.
So they refinanced. Now, fast forward, getting divorced. Like, well, I don't want to walk away from this 2.2% mortgage. Well, I've got one in Broward County right now where he's got a 2.75% mortgage. Says, Don, I don't want to walk away from it. I said, I wouldn't either. Let's take a look at what your potential solutions are. Well, as it turns out, there was other debt obligations besides just the mortgage. There was credit cards. There was a couple of vehicles, but the credit cards were big. So I'm like, well, if we're talking about rate, let's take a look at those rates.
Right.
Because oftentimes when I hear about rate, I'm like, okay, let's just stop here and have a little conversation. What does that rate mean? And typically what it means is when we really dig deep into it a little bit, it means a lower monthly payment. Because typically we're going from a 2 household income to 1. That low rate represents a low monthly payment. Okay, if we're talking about monthly payment, let's talk about overall cash flow.
Right.
What other debt obligations do you have on your personal balance sheet? Or what other debt obligations are being assigned to you from the marital balance sheet? And then let's take a overall holistic look at 30,000 foot level. Okay, let's take a look at this. what are your total monthly debt obligations? Would it potentially make sense to maybe consolidate those into one monthly payment?
Right.
And by doing so, this does require a little cooperation from the other spouse, but we can actually include that as part of the marital settlement agreement. And by doing so, now we're going to say, hey, wait a minute, let's take a look over here at the IRS, because they allow you to itemize certain expenses throughout the course of the year. In the context of this conversation, those include your mortgage interest expense and your property taxes. Okay, well, your marital status your filing status is going to change in the eyes of the IRS from married to either joint or single, or head of household or single. Let's take a look at those standard deductions. And if you were to refinance, let's take a look at what those itemized deductions would amount to. And does it make sense from a tax filing status? Because I say, listen, if you were to make $80,000 here in Florida and you were to make $80,000 in the state of New York on a tax adjusted basis, is that the same amount of income? Absolutely not. They've got a state tax and we don't. All right. So let's take a look at a tax adjusted of that rate from 2.2 to 6.5. Oftentimes, like in this example of this individual in Broward County, his tax savings are going to be in the ballpark of $8,555. And his monthly cash flow is going to improve by about $456 a month.
Can't beat that.
So that's why I understand about, and many times it does. There's 3 of them right now where I said, no, hold on to that rate. Doesn't make sense. But if you have an equalization payment, equity buyout, maybe we'll take a look at these home equity lines of credits or the home equity loans. There's a plethora of solutions. That's why we want to make that proverbial informed decision before you go down a rabbit hole, just take a mortgage application and do a refinance.
Well, let me ask this, because, where we live, we're surrounded by, I think, 5 various military bases. Military bases are very big in the panhandle of Florida. Do you do a lot of work with VA loans?
We're actually proud that the independent mortgage bank that I'm employed by, we're actually I think we just said the top 70 VA loan provider in the country.
Okay.
So I'm very fortunate that I have those resources with that department. In fact, that the gentleman who started our department was a Vietnam veteran.
Okay.
And he had a term for it, but whenever our pilots were down, he was in a helicopter, he plucked the pilots out of the water.
Right.
And he said he was like sitting back because, the snipers.
Yeah. You're just sitting there hovering.
He came back to the States in California and went to work for a mortgage company. And they said, hey, you're a veteran. Why don't you look into these VA loans? So he'd been doing them. He became one of the go-to VA. He'd go all around the country and do a lot of seminars
For
on
the military members and the people who qualify for VA loans out there who are going through this. Is there any special thing that you'd want to tell them, or you think that they should be aware of?
Well, I recently was brought in on a mediation, and the situation was, in fact, you were at CERT review as one of the AAML presenters. It brought me in on this mediation, and it was the husband was vacating the home. It was his VA loan. But he was very amenable he wanted his wife to have the home with the children, and they had a low VA rate. And his concern was potentially being able to qualify for future mortgage financing if he said, look, you just make the payments on that VA loan. So the entitlement that they had, that the VA loan program's the best program out there. So I said, look, you're going to be giving up that entitlement. It stays with the home until that loan is satisfied, the house is sold or the loan is satisfied. So you would be giving that up. But in terms of future qualification, as long as we get language in this marital settlement agreement stating that she's going to be responsible for making those payments, that'll become, as I've referenced before, a court order assignment of debt in the eyes of the next underwriter. It's not going to impact you negatively for future qualification purposes.
When you say future qualification, would that be for a future VA loan, or would that just be for a future standard loan?
So the VA's got to be for the primary residence.
All right.
Again, it's with that one property. So if she were to sell it, then it would be restored. His entitlement would be restored. It is a big give on, in this case, it was a big give on his part, but he was willing to do it for the sake of his children.
And, I find sometimes in these cases that if there is a refi option, if you can refi it or assume it or get the other person off the mortgage and get them satisfied with their equity, that, if your parents, unless it's just a really heated, litigious case that they want the kids to have the stability if they can. As the question is, can they afford the stability? Having someone like you working with them, maybe to give them an option where you can have the best of both worlds, where I can still provide the stability of the marital home to the children, and I can still move forward with my life and qualify or get another mortgage. That's invaluable in those scenarios where you're trying to do both, do the right thing and, move forward at the same time.
Well, and I also have that conversation because, look, I understand, having been through it myself, you want the stability of, for the children. But okay, like I said, let's talk about rate. What does that mean? Well, let's talk about stability. What does that mean? Because children are going to have activities, and I know those activities typically aren't cheap.
Oh, yeah.
So does stability mean that roof? What are they going to say? Or stability mean the lifestyle that they know it?
What they've become accustomed to.
Right? So let's talk about that. So
I have that conversation a lot with child support. And, sometimes I'll have, people who are upset about what the guidelines yield. And then I'll remind them, like my favorite example is one day before I left the house, I think it was $200 or $300 in yearbooks, karate dues, and when you look at the child support number, I'm thinking, I see why you're upset. There's some resentment and there's, just some, unfortunately, bad blood, but you're actually probably coming out cheaper than if you were getting hit up every morning with, oh, by the way, Dad, I need this and I need that. And, that adds up. And I think, sometimes people really don't, I think what you touched on, they don't really, take it into account, the lifestyle that we give our children, with yearbooks and karate and so many more things than that were available as options to these kids. My wife is a big baseball fan and my son is a baseball player. And, we used to practice a handful of times and you had your game. So now there's, practices twice a week. You got a game. When you're not there, you're in a facility we used to have here called the dugout, and all that adds up. And people just don't really realize how much you spend on maintaining your children's lifestyle. So that's an excellent point. You don't want to be house rich and then not be able to provide, what, a standard of living to your children or to yourself.
Right. Right.
So, when working in one of these cases, I'm assuming the smart money is on bring you in early. Don't bring you in late after the agreement's inked, or people maybe have cemented their positions, maybe early enough on where there's still some flexibility and let you help be an architect of the agreement.
Look, again, I've said this before. I don't want to sound like broken record. I've been there. I know it's an expensive process, but let me tell you something. There was no one like me around for mine.
Right.
It cost me tens of thousands of dollars. I walked out of that courtroom and I thought, what just happened? I really did. What just happened? 6 months later, I was like, oh my God, it was tens of thousands of dollars. So if someone had come to me and said, hey, Don, look, for a few $100s, I'll advise you on what your potential options are and your solutions and strategies that are available to you. Yeah, I would have been like, got to pay someone else. But in retrospect,
it reminds me of a story where a few years ago when the rates were low, we had an associate attorney who was working with us. And, I want to get a house. I want to get a house. My wife wants me to get a house. I'm trying to save up for this down payment to get the house. I want to at least have this much down payment. So I pulled up a mortgage calculator. And I said, how much house does your wife want? And it was like $400,000. I'm like, okay. So put in $400,000 in there. So let's just say that the bank will let you borrow all of it, put the full 400. I said, put in at that point, I think it was like 2.5. So I said, put in 2.5. I want to say the payment was about $1,600. I said, go in there and put in 6.9 now. So, because I think when I bought my first house, it was 6.9. So let's just go with that. And he put that in there. And I want to say we were knocking on the door of about $4,000. I said, now that's a $2,000 a month difference roughly for 30 years. So let's do the math on that. And he was like, I'm going to the bank today. I was like, I think that'd be a really smart choice to go to the bank right now. I was like, in fact, take the afternoon off and go to the bank. So if you can save on that interest over the long haul, even if you save a couple $100, but if you go at, you're thinking of a 30-year note, that's going to add up very quickly. And I think that's invaluable. So attorneys that want to collaborate with you or get you involved in their cases, when should they reach out? How do they reach out? And what's the best way of making introductions here to the client and kind of getting that involved, getting this process rolling?
Yeah. So let me answer it this way. If I have not had an opportunity to meet with the attorney, I'd encourage that. And I'm all over. I'm in Fort Lauderdale right now. I'm getting ready to leave. I'm going to Tampa for the next 2 days, then Orlando. So that's just my life. And then with some of your colleagues up in the Panhandle now, speaking of the CJE, they've now said maybe we could do that up here.
Yeah, we need more of that. And if there's anything I can do to help you facilitate that, you let me know, because we need some more CLEs this way, and we need more, judicial training, I think, as well. So whatever we can do to help, let me know.
So if I haven't met them, I would encourage them to get in touch with me, and whether if it's feasible to have a breakfast or lunch, or maybe like a Zoom, get to know each other. And then in terms of referring the clients, the most effective way, and this has taken me a few years to figure it out, because I'll walk into maybe a family ends of court dinner. I'm like, hey, and someone will say, Don, did my client call you? It's, no. And then I finally figured it out, because when I was in the equivalent of your office, I was given a homework list, and I got in my car and I put that homework list down. I said, that's the last thing I even want to look at, because this is a bad spot.
We hear a lot, I'm paying you to do that.
Yeah.
And I'm thinking, well, I'm going to do my job, but you got to provide me the information so I can help you. Or
right.
People get the mandatory disclosures are the one that gets us the most. Like, what am I paying you for if I have to go gather it? And I'm like, remember, and I use this as things. It's like, remember when you applied for your mortgage and you had to turn over all that stuff? I was like, this is the same exact thing.
Oh, yeah.
I was like, it's not fun. I know when I got my mortgage, I did not enjoy gathering up everything, every pay stub and tax return, but you have to do that. But yeah, homework often does not get done, and then people wonder why the case gets delayed. So if you're out there and you're listening, do your homework. If your attorney tells you to call this professional and get some advice, then please don't pay your attorney not to listen to them. That's not a good economic choice.
No, it's just going to cost you. In fact, I do a lot of work with mediators, and one of the biggest frustrations mediators across the board say that what parties will come in without having done any homework. Well, I want to keep the home. Okay, have you talked to somebody? Have you figured out the feasibility? So that email introduction is the most effective way to make that introduction to the client. And what happens is I'll respond, say, you'll say, Mrs. Smith, this is Don. I told you about him. I'm Don. This is Mrs. Smith. I'll respond, hey, Gerard, thanks for the introduction to Mrs. Smith. Mrs. Smith, if you'd like to schedule your complimentary 30-minute Zoom consultation, click on my calendar link here. Then Mrs. Smith is in control of what time works for her. There's some questions that she needs to answer prior to getting to the scheduling component. So I know I'm at least enlightened and educated on what I'm walking into to provide, a worthwhile 30-minute consultation. We go from there.
I think that the information you've given me today is just in and of itself mind-blowing. How we structure these things. You've made me a believer on there will be no more go talk to your local bank. And you might be able to get some of that information, but I would think from our conversation, getting you involved in the beginning, if you have somebody, if you anticipate either your client's going to want to keep the house or the other side's going to keep the house, what is the best way we set either one of them up for success when we structure the deal and the words we use to get them through this with the least amount of cost, headache, and, and time is invaluable, speed. Because there may be an opportunity you want to take and you can't take that as long as the other mortgage is still there, or, then you're missing out on a house that you wanted or some opportunity that you wanted. So I see that you're an affiliate member of the Florida Bar Family Law section. Can you tell us a little bit about that and how you, become an affiliate member?
So that was 4 years ago. One of the attorneys very involved with the section had recommended that it was a cert review. So it must have been 20, if I'm doing my math, 21. And before cert reviews, the class starts, the review course starts, that day before is all the committee meetings. So that's where I met her. And she said, and people have been talking about how the family section has these great retreats, and they went to Napa and they went to somewhere up in the East Coast near Maine.
I'm going to give a shout out. The section does do some good retreats, and Willie Mae Shepherd is pretty instrumental in getting those going. I was a little jealous, though. I think the workers' comp people went snowmobiling. I was telling her, I was like, is there an opening in that section? Can I get in there? And she was laughing pretty hard the last time I saw her. But
I saw her and I met her husband he was at the family section, did a CLE live event in Jacksonville.
Yeah, I was there. I
Yeah.
don't think I bumped into you there, but I
Yeah.
bumped into you at the cert. But yeah, he was a nice
And
guy.
he was saying he was excited about going snowmobiling. He'd never been. I
Yeah.
said, I've never been on a snowmobile.
Yeah. Well, do we need to up our dues, Willie Mae? Is that what it is? Like, what do we need to do to get snowmobiles?
Yeah. So this was at the committee meeting, and she said, Don, they've got I thought she said they got a Napa committee. I said, I'll join that. That'd be great. So I go walking in this room. It says, welcome to the NAPO committee. I said, NAPO. I said, yeah, non-attorney professional outreach committee. I'm like, I got hooked into this. I thought I was going to Napa. So I've been on that committee ever since, and it's been great. It's at least gives me somewhat of a seat at the table with other non-professional, the allied professionals, and so that's how I became involved.
I don't know about other sections because I only put all my time energy into the family law section, but I think that's a really neat thing about our section is when you go to CLE or the cert review, and there are accountants there. There's obviously mortgage now as mortgage specialists that are there. There's people from like companies like SoberLink or My Family Wizard, and there's so many different professionals that kind of support our section who have just vast amounts of information and the connections you can make to help somebody through one of these cases. I now know who I need to call, or I know who can help you with this problem. And having that support system is, one of the things I think that's really great about the section. In fact, I really like it when we have opportunities, CLEs, when we don't have all lawyers talking. I know a lot of what the lawyers are saying, but having, for instance, you talk about mortgages for half the day, it would be eye-opening because we've only talked for a few minutes here and you've already taught me some stuff that I would have never thought of. So, I think that's really great that, we have that as a support system within the section. If there's another attorney out there or there's somebody who's going through one of these divorce processes and they need to get up with you, Don, how do they reach out to you to get this ball rolling?
Sure. So the easiest way, you can Google me, Don Moll. It's not me. There's a couple women in the office that do all that SEO, whatever stuff. So I guess when you Google me now, at least it's not a mugshot. It's my divorce mortgage guy, or it's a pretty easy website to remember. It's the divorcemortgageguy.com. So if you go to the divorce mortgage guy, there I am.
Well, when I saw your table this winter, that was the URL and the title was pretty catchy and pretty easy to remember. Go ahead.
And that came up. The genesis of that was I was calling one of my referring attorneys in Orlando. And and she had just hired a new paralegal. So the paralegal was doing her job. She says, are you a client? I said, screen the call. No. Are you calling about a client? No. Well, who are you? And I was like, how am I going to explain this? I said, I'm Lauren's divorce mortgage guy. And she said, I didn't know there was such a thing. I said, neither did I. So I just now said it. So I was walking the next day and I thought, I wonder if that website's available. So I went on to GoDaddy. And for $11.99, divorcemortgageguy.com was available. So I grabbed it. And then I was at cert review and one of the couple of attorneys said, Don, you better trademark that. It's all been it's been fun, just the journey of this thing.
Yeah.
So,
well, it sounds like you have a real true understanding and passion of it. And, you've made a believer out of me that definitely there are cases that would greatly benefit from having your help in the beginning. And, whether it be, for structuring it or litigation strategy, and just, I'm a big believer on if we can get it settled quickly and we can create less scar tissue then for this family going forward and maybe giving everybody a better future, than having the right team who can tell you this is possible, this is not possible, this is how we can get you there early on so you can make the best decisions and get this thing over and behind you. However, if you got to go to trial, you got to go to trial. And then you need even more your network of professionals. So I can say, maybe I called Don and put him on the stand and I'm asking him questions about, how many months will it take to qualify, how many months of steady income, and not to sound condescending when I say it, but educating the judge, because the judge may want to give you what you want asked for, but may not realize that they may think when they draft the order, they are giving you exactly what you asked for. In reality, they've accidentally shut the door where it's not going to be possible. So,
and I've testified twice this year. And in fact, and I was I didn't realize the attorney's OC was not exactly friends with the attorney that retained me. And so I was like, oh boy, here we go. And the OC, but it was more the judge that had more questions about my report, because I generated a 12-page report and it covers all aspects. But the judge just said, okay, well, educate me on this. So
I think the judges appreciate they have a very hard job, and family law covers a lot of diverse topics. And at least in our area, a lot of our judges they're normally appointed by the governor. There's not a whole lot of judicial elections that go on, and they have a very strong background, usually from the prosecutor's office in criminal law. And then what we see a lot of is the younger judges who are new to the bench end up with their first tour being in family law. And so they're craving that information. And, it's always a good thing to provide the information to the judge. And I tell people, my personal opinion is, spoon feed the judge, make it easy on the judge, write the judgment up in a manner where the judge would be proud to sign it when it comes across their desk, and that this is a great piece of work. And you'll be surprised how much weight that can carry in the case, rather than the gotcha moments of cross-examination, but who really was there just to provide good, solid information and good, solid work for the judge to build their opinion and their decision on.
And I hear that, again, I go all across the state, all different jurisdictions, and a lot of these family events, whether it's luncheons or CLE events, and they'll have a judicial panel or a GM panel, and it's pretty much across the board. Just give us some.
Yeah. And they don't know. There's so much family law. I don't know anybody who could know every detail of it. And then in addition, the mortgage industry, all the tax ramifications. So putting together that team is crucial. Look, Don, we're about to have to wrap up, but I'm going to ask you one final question. If you could tell the world anything you wanted to about divorce and mortgages, what would it be?
You cannot think traditionally when it comes to mortgage planning when going through a divorce.
Right.
It is not the same process. And apologize on the behalf of the mortgage industry. There's not enough guys like me or gals.
Well, I think that you've changed my traditional mindset in just the last hour. And I look forward to working with you on some cases now. I'm excited. And, we will definitely have you back on if you're interested in coming back on, and we can navigate this further and unpackage some of the things that you've discussed today. And we appreciate your time, and thank you so much for coming on.
Absolutely. No, thank you for the opportunity. This has been.
Thank you.
Okay.